Supreme Court in the matter of KUNCHAM LAVANYA versus BAJAJ Allianz General Insurance Company Limited allowed the appeal and set aside order of High Court and restored order of MACT. Court said that in conspectus of the emerging background, insurance company cannot be said to have been successful in establishing that it was not liable to pay for the accident committed by offending vehicle, which was insured by taking plea of violation of any terms and conditions of insurance policy by driver. On 20th March 2011, Mr. K. Yadagiri was riding Bajaj scooter and going from Habsiguda to his residence at Taranaka. At 9:30 p.m., when he reached Taranaka, his scooter was hit on backside by red-colored Hyundai Verna bearing registration number 3763 that was in high speed and being negligently driven. Due to accident, Mr. K. Yadagiri suffered multiple injuries and was taken to Gandhi Hospital through ambulance, where he succumbed to his injuries. In this regard, FIR was registered under Section 304A of IPC on the next day, 21 March 2011. Appellant claimants, being widow and children of deceased, filed the MBOP number 458 of 2011 before MACT claiming compensation of 23 lakh rupees. Appellant examined 3 witnesses and submitted 12 documents. Respondent 1 insurance company did not examine any witness but submitted single document insurance policy. MACT also examined investigating officer as court witness. After appreciating material before it, MACT allowed petition with costs against respondent jointly and severally and awarded compensation of 33 lakh 63,350 rupees with 7.5% interest from date of filing of petition till realization. Respondent insurance company before High Court contended that registration number of offending vehicle was unknown on the date when FIR was lodged. High Court wide impugned order allowed appeal and set aside award qua insurance company. While doing so, High Court noted inter alia that PWTO eyewitness maintained studied silence for 2.5 months, even though he had written down registration number of offending vehicle and hence his testimony was unreliable and appellants had failed to establish offending vehicle was involved in the accident. The very fact that case was registered against unknown vehicle initially would indicate that offending vehicle was not identified. However, since FIR is not expected to be encyclopedic and is only for purpose of putting into motion criminal law such that thorough and full-fledged investigation by police ensues, it is duty of the investigating agency to find out identity of culprit, which in present case would be offending car and driver, and take action in accordance with law. Thus, mere fact that initially FIR records the vehicle as unknown would not be fatal for the prosecution claimants to later come up with specific identity of the vehicle driver, with obvious caveat that connection of the accident with said vehicle had to be based on cogent and reliable evidence. In present case, factor in favor of insurance company was that conduct of the so-called eyewitness, who was consumer at pawn shop, gave his statement to police about 2.5 months after accident, disclosing registration number of the offending vehicle. MACT's award had fastened liability jointly and severally on owner of vehicle and insurance company, which had been set aside by impugned order to extent of imposition of liability on respondent. Owner had neither appeared before MACT nor before High Court and not even before this court, despite valid service of notice. In backdrop of these discussions, in opinion of the Supreme Court, respondent 2 had to take responsibility. Court was left with no option but to presume that owner of alleged offending vehicle, which was cause of the accident, had no defense to offer before the three fora, including Supreme Court. Moreover, it transpires from record that during police investigation, when owner of vehicle was confronted, he telephoned driver, who as per police version admitted to accident in question having occurred. Respondent 2 had given statement to police to effect that he was not aware of driver of car having caused accident, resulting in car dashing the deceased Bajaj Chetak scooter until police arrived at his house. When owner telephoned driver, he confessed to his guilt and was immediately handed over along with vehicle to the police.